Rice, the Boston Supreme Court analysis, Honorable Chief Justice Vargas Court signing. Good morning, councils. Will the clerk please call the case?
This is Supreme Court case number CRA21-015, People of Guam, Plaintiff Appellee v. Louis Anthony Vargas, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Marianne Wallachuk. Appearing for Defendant Appellant is Attorney Braddock Huseman. Panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carvalito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Huseman reserves 5 minutes.
All right, thank you. Give me 1 second. I need the Zoom link for the. Just let me log into the Zoom link for the purposes of the court's YouTube channel. And thank you, counsel, for both coming in and proceeding with the arguments today. I know that, we're in a bit of unstable times with the recovery from the typhoon. And I know, Mr. Huseman, you were gone for a little bit, but managed to make it back. And obviously, we weren't going to be proceeding with arguments during the time originally scheduled. We had our sights set on other matters, but I'm glad that we were able to at least come in today and continue forward with the arguments that we have, and appreciate counsel's indulgence. We're still on an unstable power supply, and unfortunately our generator is not functional. So hopefully we'll make it through arguments without any issues. But in the event we might have to take a break and go forward with that. So give me a second here. I'm just going to try to log in. Trina, it's not linkable. It was just a photo. Just give me a second. I need it as an email. Huh? I have the meeting ID, but it got a copy everything. It's okay. I should have put this up. That's right. No, it's okay. I'll do it. Camera's turned off. Yes. Justice Merriman has to turn on your camera.
Shelter. I did the same. Mine just wiped out, but I got it all back on. Yeah. Test.
Recording in progress.
All right. I'm in now. All right, I think we're ready to proceed. Test, test, test. All right. Let me just. All right, Trina, if you can just correct the pictures and we'll be ready to start. Let me just change my background. All right, thank you. Sorry for the delay. Will the clerk please call the case?
This is Supreme Court case number CRA21-015, People of Guam, Plaintiff Appellee v. Luis Anthony Vargas, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Marianne Wolochuk. Appearing for Defendant Appellant is Attorney Braddock Huseman. Panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Huseman reserves 5 minutes.
You may proceed, Mr. Huseman.
Morning, Your Honors. Mr. Chief Justice, may it please the court. The government of Guam charged Luis Anthony Vargas with 14 counts in this case. The government of Guam had an army of experts and was able to call upon a bunch of witnesses, including Mr. Vargas's ex-girlfriend, Ms. Rusk, to support its case. But at the end of a 12-day trial, the best the government of Guam could do was a single conviction on a second-degree charge. To get to that single conviction, however, the government of Guam and the trial court had to cheat by denying Mr. Vargas's constitutional rights. And they both cheated in 3 ways that I'd like to cover today. First, the trial court denied Mr. Vargas the use of an expert witness during the preparation and evaluation and ultimately the presentation of his case. Second, Mr. Vargas was denied the ability to call witnesses on his behalf. And third, the prosecutor committed prosecutorial misconduct. I'll cover all those 3 points today, but first I'd like to cover the denial of an expert.
There were 2 different orders issued by 2 different judges concerning the expert. You argued that the first order was irrelevant and that the focus should be on the second order and that the judge abused his discretion. But the judge in the second order granted the expert, the hiring of the expert. And so how did the judge abuse his discretion? I mean, you didn't raise the issue of the continuance. You indicated, of course, that the judge, it was only the time was the Friday before trial. But you didn't ask the judge for a continuance once the expert had been appointed because of the time to find the expert and to prepare him and to have him available for cross-examination. So, considering that he granted the motion, how is it that he abused his discretion?
Well, 2 ways. So first, to be clear, I was not trial counsel. That was
I understand.
Okay, understood.
I say that generally.
And I take that. I'm sure I'll make a similar general announcement today as well. But to your question, the reason the trial court abused its discretion is the minute it declares that the defendant has rights, and it did declare the defendant has rights. He's entitled to an expert witness. Well, Aki, and I believe this court, the U.S. Supreme Court in Aki and this court in Santos require some things for the defendant, and that is at a minimum, it's the presentation. It's not just the presentation, and you can argue that there was a bit of presentation here because the expert did get to testify, but the expert was not used and could not be used for the cross-examination. But more importantly, the problem here is that there was no pretrial use of the expert, right? So what the trial court did here is basically turn the expert the use of an expert on its head. Generally, what a trial court or what a trial counsel will do is present the case to the facts to the expert, and the expert will opine, and they can come up with, hey, I'm fine for this. You might need another additional expert. Here's a way to attack this. They can come up with ways, and this is in the brief, to present the case, to evaluate the case, and to prepare for the case. But after 2 years, the cake is baked. Every trial lawyer in this room knows that, right? There's nothing going on that weekend before trial that's new and fresh. This is the plan of attack is set forth. And so when you
But
have,
couldn't they have filed a motion for continuance and then gotten the time that they needed to prepare effectively?
I'm sure it could have, but I think, and this is presented in the supplemental excerpts of record that Mr. Vargas put, the court actually preempted that and actually announced why we were rushing to trial in this case. And but the reason why we're rushing to trial is patently obvious in the record, to me anyway. And that is the presiding judge is telling the executive director of the public defender's office that the public defender is asserting speedy trial rights on behalf of other clients, and it's clogging up his courtrooms. And so we're going to have to go forward with trial here. He's preemptively shutting that avenue down. And the problem here is that answer and that what's in the record there has nothing to do with Mr. Vargas or Mr. Vargas's rights, and everything to do with I'll call it a policy dispute between the Superior Court and the public defender's office.
But what the government and the trial judge, and I think it goes even more to the first order, is that there needs to be a showing of a particularized need, and merely stating that it's necessary for the evaluation, preparation, and presentation of the defense, and just using those words was not sufficient. And so, and at least as to the first order in terms of the trial court, the trial judge there. So what was expressed as the particularized need, other than that it's generally helpful to have this expert witness in the evaluation and the preparation and the presentation of a defense that it's necessary.
Okay, well, to answer your question, Your Honor, I think the first, and like I said, and I agree with Justice Torres, I do think this first order is irrelevant, and I don't believe the second order or the first order are under appeal. So I think the court is bound by those. Those are fact findings. And the fact finding is he's entitled to an expert. But to answer the court's question, I think the first motion was for assistance in cross-examination, and I think that qualifies. So what I would say is this: when you have an expert, and I think this is clear in not only this court's precedent, but in other courts' precedent as well, that this court relies on, U.S. Supreme Court, some California cases, where this particularized need is also a bit of a sliding scale. So in a case where the government is using DNA identification expert, expert testimony, expert facts, that's a much different situation, for example, than a defendant who has signed a confession and is on tape confessing and asks the court for a voice analysis expert because he's saying that that's not really him on the tape, right? Well, what is the particularized need here? You've signed a confession, and you want to have an expert to attack the voice recording. That a court would be completely within its rights to turn that defendant down. Here, where the state is using its resources and its power and is stacking an array of expert testimony. Again, I think it's somewhere around 17% of its witness list is an expert or expert affiliated group, and is going to use its power to bring that down on an individual, it behooves the court to take a step back and consider what's actually going on here. In this case, the defense counsel is saying, I need help doing YSTR DNA cross-examination. I really don't know anything about it. And we've provided cases from other jurisdictions where the lawyer flat out said, look, this is so complex. I have no idea what's going on. They're going to use, and it's not just the DNA, right? The guanine thymine, when you map the DNA out, it's the that's an incredibly complex subject. But the statistical science behind DNA identification is obviously difficult, and difficult in this case because even with expert assistance, and we'll get to this, the prosecutor conflated two types of DNA. And so that's how I'd answer your question, Your Honor, which is to say that he did recognize a particularized need, but I think the court is bound by the second opinion. The second order finds that he's entitled, and this court in Callahan said prejudice is assumed when an expert is necessary, and the trial court found that an expert was necessary. And in this case, an expert has to mean something. It has to, and if this court takes an exception to the Aki's rule, which is that an expert is needed for the preparation, evaluation, and presentation, and then just say, well, as long as the expert testifies, that's okay. It creates a giant loophole that swallows the Aki rule, where every judge can turn a litigant down and say, you're not really entitled to a.
So your argument more is the delay in ultimately getting the expert is the prejudice because for some reason trial counsel wasn't able to effectively benefit from the expert's services in the cross-examination of the expert witness.
Well, that's part of it. I'm saying that there was no preparation and there was no evaluation either. That has to be the case because he wasn't retained by then. He had the trial counsel had mere hours to do it. But if you look at the record, and we've pointed this out in the brief, the government isn't satisfied with cross-examining the actual expert without its expert commenting, and they get to huddle and decide where to attack. And that wasn't available to Mr. Vargas because of the late appointment. And that's why I say that I think even the presentation of his case was harmed. So every phase that Aki requires.
So it wasn't really clear, at least to me. I mean, I didn't go through the record close enough. So at what point was the expert available to trial counsel during the course of the trial?
I don't think it's in the record, Your Honor, and I actually don't know the answer to that. I know that as soon as they were allowed to retain an expert, they took efforts to retain it. But as the Superior Court, as the presiding judge said in this case, good luck finding an expert. This is the eve of trial, right? So and at the beginning of trial is when the government called all its experts.
So there's nothing in the record as to when Dr. Kramer testified that the defense's expert was already on retention and able to guide defense counsel through Dr. Kramer's testimony?
I'm not aware of anything in the record that states that. I don't have anything that identifies when that wasn't an issue at trial. So I do not know when the defense expert was retained now.
Well, we know clearly that it was at least on the 6th day of the 12-day trial.
Yes, Your Honor. And again, I do not dispute that the expert did testify, but I do dispute that the expert, because it's not clear from the record. It's not clear. There's no evidence that the expert was used for cross-examination. The government's experts were first front out of the gate. The government asked for extra time to review my client's expert testimony, and I assume, but it's again not in the record, that the silence on our end is because we didn't have an expert yet. I mean, this isn't just you can go get an expert. Oh, I have an expert in my back pocket. This is find the expert, give the expert the material, fit it in with his schedule. I mean, this is really, really late. And that's why we say that it's not just the evaluation, not just the preparation that was denied. It was the actual presentation. And that is an error under Callahan. And we believe that Mr. Vargas is entitled to a trial because of that. There are no other questions about the expert. I'd like to talk about the second issue today, which is the trial court's violation of Mr. Vargas's Sixth Amendment right to call witnesses in his support. Mr. Vargas has a Sixth Amendment right to confront his accusers, as well as to call witnesses on his behalf. And there is a credibility problem with one of Mr. Vargas's accusers, Ms. Rusk. Specifically at trial, Ms. Rusk testified that she had never been the victim of a sexual assault and that her daughter, LL, was not the result of that sexual assault. Mr. Vargas, however, had evidence through the testimony of Jonathan Morgan that Ms. Rusk had claimed to have been the victim of a sexual assault, and that she had claimed before that her daughter, LL, was the victim of that sexual assault. So to put differently, Mr. Vargas has evidence that Ms. Rusk has lied to the jury about sexual assault in a sexual assault trial. This is obviously relevant. It's obviously critical evidence. And the trial court denied the ability to call that witness on the basis of a rape shield law, of Guam's rape shield law. That is an inappropriate use of the rape shield law for the single reason that Ms. Rusk was not the victim of sexual assault.
I mean, even if the trial court made an error in its analysis of 412, and I didn't see that it did the weighing of factors to do a 403 analysis that the government says it's potentially excludable under 403. What prejudicial effect occurred? What was the harm in allowing this to go forward? How did it affect the verdict beyond a reasonable doubt, harmless beyond a reasonable doubt?
Well, it affects she's one of the accusers. So they have their scientific evidence, which again, Mr. Vargas is one hand tied behind his back. And then the other prong of this case, the other stool of this case, is the eyewitness accounts. All right, well, now there's a credibility problem with one of the eyewitnesses, perhaps the main eyewitness. I think the case law is clear. We've cited case law in our brief that when, and this is the Atkins case out of Kansas, the Supreme Court of Kansas, that in that case, it's very similar fact patterns. It's a mother and a daughter accusing a father of sexual assault. And in that case, the difference is they didn't, all the parties, court included, agreed that the rape shield law didn't apply, but the court had excluded it for relevance reasons. And the Supreme Court of Kansas is like, no, this is obviously relevant. You can't convict an individual and shield their accusers from the light of cross-examination and from the light of prior inconsistent statements, especially when it's directly relevant, and here it is. And so that's why I think it infects the trial with an unfairness that really is a problem.
So as the government argues, so just having, although it may constitute error in not allowing the prior inconsistent statement process to be applied, for if there was the additional testimony of the victim herself and then the DNA evidence which points to guilt, you don't feel that that's sufficient in reference to the other evidence that points to the defendant's guilt in this case?
Well, and this becomes the problem because again, there were 14 counts in this case, and the best the government could do was one. So this isn't overwhelming evidence. So I would dispute respectfully dispute your characterization of that. I would say that this is a close case. It's a close case because the jury had a hard time with the case. It's also when the government says that they're bootstrapping the DNA evidence to bolster the problems with their direct testimony. The problem is there's problems with their DNA evidence because they tied my client's hands behind his back. So what the court is asking is, at the government's behest is, I mean, he's guilty. Does he need a fair trial? Well, the problem with that, of course, is the DNA evidence here isn't as clear as the government wanted to make it. That's clear from the jury verdict. If he would have had an expert assistance at trial, they could have attacked the DNA evidence better. He would have had evaluation and preparation, and then to claim that well, you had at least one witness that wasn't cross-examined, but the other witness was shielded from cross-examination. Well, that's patently not a fair trial. And it does no good to use circular reasoning as the government did to say, but he's guilty anyway. That's not how the system works. And respectfully, if he's entitled to a fair trial, and he did not get one here. And so if there are no other questions about the trial court's denial of my client's Sixth Amendment rights, I'd like to use my remaining time to discuss prosecutorial misconduct in this case. Here, the misconduct came in two forms, but they both deal with the same issue, which is commenting on facts that are not in evidence, and they came in a bit of a different way. First, there were leading questions in forms that there were, this evidence was hearsay as it sat, right? So initially, when the prosecutor tried to elicit this information, it was hearsay, because there was a U.S. Air Force investigator, and he had done an investigation, and the prosecutor is trying to get facts about what's in his report. Instead of calling the individuals who made up the report, she was asking questions from the investigator about what those individuals said. Well, that's hearsay, and it was disallowed. So the prosecutor switched tactics and then announced what was in those reports. And this isn't in the record, but and I'll stop if the court wants me to, but incorrectly characterized what was in those reports, and presented those facts to the witness and got the witness to agree with them. So these are hearsay facts that don't exist in the record. But they're not even the actual hearsay facts. They're the prosecutor's characterization of what the investigator was told, presented to the jury without cross-examination. And as we've pointed out, there are multiple cases in California where when the prosecutor testifies like she's doing here through leading questions, it's dynamite to the jury, but just garbage as a matter of law. And the reason it's garbage doesn't mean anything what her characterizations of that evidence are. What is inappropriate? The only way to know what inappropriate was in this case is to put the prosecutor on the stand and ask her what she meant by inappropriate. But she is giving the jury permission to convict him because he's inappropriate around children, and he's inappropriate. All the adults say so. But this is the time, and
there was an objection in terms of from this in reference to the examination of the Air Force employee here, and so it's then that would be the harmless error standard. And there was a jury instruction given, wasn't there, that anything counsel says is not evidence, and it's just that's just our argument.
Sure, I think there was a blanket statement, but again, this is a leading question of, well, everyone knows he's inappropriate with children, and the investigator is saying yes. So again, the problem here isn't that you can disregard. It's a trick question. It isn't that you can disregard what she said, because what she said is she wrapped it in a question and fed it to the investigator, and that's one, obviously an improper leading question, but it's her characterization of what's in there, and that particular instruction doesn't cure the problem, because the testimony is like, they're inappropriate. Okay, well, now it's what the investigator said, because she put words in his mouth. And she put words in his mouth that were facts that were not in evidence. And that's, you can't do that when it's on closing. And so the idea that you could work your way into that on direct examination is just, it's verboten. It's, and again, I put this in my brief. I'm being hard on the trial attorney, but I'm not saying this is necessarily a 10 or bad act, but it is what it is. It's prosecutorial misconduct. And it's a prosecutorial misconduct that infected the trial. It allows the jury to convict on something other than the evidence in front of them, on her characterization of what somebody else said. And that's completely improper in this case, because when you say, when there's a sexual assault case and you're the prosecutor and you establish with the witness that, okay, so you have, and this is clear in the record, you conducted an investigation, you know what those parents said, right? Yes, yeah, I know exactly what they said. Okay, well, they said he's inappropriate, right? Yeah, he said that. Well, you're giving permission, everybody in that jury knows what inappropriate means in a sexual assault case. But again, the only way to know what inappropriate actually meant or what her characterization of it was is to subject her to cross-examination, but you can't. She's the attorney. And that's why this kind of thing isn't allowed. And it was objected to, a mistrial was asked for, and this kind of misconduct infected the entire trial. And Mr. Vargas is entitled to a new trial because of it. The second type of attorney misconduct, prosecutorial misconduct, wasn't objected to. And so that's a more difficult standard. We admit that. And that happened at closing, where the prosecutor conflated two types of DNA tests. So there's one type of DNA test in this case that is highly specific and found where you would expect it to find on interior of clothing or on his items. And that was within, that excluded almost everybody, I think everybody on the planet aside from him. That's highly specific DNA evidence. And then there was another YSTR DNA evidence that came from 5 or 6, whatever it was in the record, different cells of male DNA, which is a completely different type of test. And this is where it goes back to the statistics. And that happened to be not 1 in billions and billions of people, but 1 in 250, 1 in 86, 1 in 96. That's in the record as well. And so we're talking all of a sudden about millions of people. This isn't a direct identification at all. And she conflated those two tests and told the jury, you know, what's his DNA doing there? Well, she had no evidence that his DNA was there. That's the problem with this type of evidence. And it goes back to my first point, which is this is a very difficult case to try without an expert. And if the court has no more questions, I'm a little bit over and I'd like to reserve the remainder of my time. But what we're asking for is any of these 3 reasons are enough to give Mr. Vargas a new trial, and we're asking for a new trial. Thank you.
All right. Thank you, Mr. Huseman. Swalowschuk.
Chief Justice, may it please the court. In this case, the defendant is asking for a new trial, but he is not entitled to one. The trial court's rulings were correct, and he was given all the due process that he was entitled to. And so I will go through the 3 issues that he raised, starting with the experts. In this case, in order to be entitled to an expert, the defendant has to show 2 things.
The court's already determined he was entitled to the expert, right? So we really don't need to examine that. I mean, at least in the second opinion, the court's made that decision. So whether he was entitled to an expert or not, I mean, no one is claiming he wasn't. I think it's more a question of the timing of the appointment of the expert and whether the expert was able to provide the assistance to the defendant in the trial, not only for trial preparation, but for cross-examination of the government's witnesses. Right.
Yes, Your Honor. And so the second order that you get here doesn't say that the first order was wrong. It just says that it's going to allow it now. And as Your Honor,
well, he argues the first order is irrelevant.
Yes,
I mean,
he did.
And he's not arguing on appeal that first judge necessarily abused her discretion in denying the appointment of an expert.
We did point out the reason for the delay here is on the defendant. The defendant is the one who waited for a very long time. He waited until there was a new judge and then had gone to trial almost. So I think like almost 18 months went by before he moved for reconsideration. This is something he could have done much earlier. He could have done it with the first trial judge. He could have done it when the second trial judge was first assigned. He could have tried an interlocutory appeal, or if this is such a clear case that he is entitled to an expert, he could have, applied for a writ, because it's practically ministerial if it's so clear that he's entitled. He didn't do any of those things. He waited a really long time. And then, not only did he miss.
Was the appointment at the time the appointment was made sufficient to enable him to adequately prepare for trial, to basically comply with the requirements of AID and allow, in this case, the government asked for additional time to prepare to cross-examine their expert, and the government's expert witnesses were in the early stage of trial. It's not clear from the record when he was retained, but clearly there was a very short period of time between that and the initial, there's nothing to suggest that he was available during the cross-examination of the government's expert witnesses.
And there are things, Your Honor, that the defendant could have done. He could have asked for a continuance for his expert so that his expert could have more time to evaluate the reports from the other witnesses. He could have recalled those witnesses and questioned them after, consulting with his expert. And then there's the other thing, which is that there's
Ms. Wallachek, all these things you're suggesting, do they rise to a waiver of his rights?
I don't know if I'd call it a waiver, Your Honor, but it's
Isn't that
possible.
what it has to be, a waiver?
Yes, Your Honor. Because there are things he could have done and he didn't do. So you're right, Your Honor. It's a waiver of sorts. We would call it a waiver. The other thing I want to point out is there's no prejudice here. The DNA expert that defendant managed to retain is Dr. Danielson. He did an excellent job. He managed to, put the people's expert on a back foot because, she didn't use the right terminology. He explained.
That wasn't doing cross-examination. That was doing direct testimony. When the government's experts were testifying, it's not clear that they had the services of their own expert witness to help them with the preparation for vigorous cross-examination of the government's experts. And obviously the government felt it was important to have time to prepare for their cross-examination of defense's expert because they asked for a continuance.
Yes, that's right, Your Honor. And in this case, the defense expert was able to look at their testimony after the fact. So it wasn't something that the defendant was able to cross-examine on at the time, but he did bring it up later, and his expert managed to discredit one of the people's witnesses. Not only that, but he also explained other ways that the DNA could have been introduced into the victim's body. He was obviously effective because 8 out of 8 counts of first-degree criminal sexual conduct, the defendant was acquitted. And all but 1 of the counts of second-degree criminal sexual conduct, the defendant was acquitted. And in the Santos case, this court has held that cross-examination is sufficient to undermine the government's theory. So in this case, the defendant was able to bring out during Dr. Danielson's direct testimony that, the government's case is not open and shut as to all the counts.
But Ms. Wallachek, cross-examining a witness is a lot different than one expert testifying. So then you get a he said, she said kind of thing instead of challenging the expert when they're testifying. Isn't that a big difference?
It is a big difference, Your Honor, and there's the possibility that the defendant could have recalled those witnesses, but chose not to. He chose to instead just put on Dr. Danielson, and he didn't ask for a continuance for Dr. Danielson. So he didn't even do the things that he needed to do to be, ahead of time in order to be able to do that. Yeah,
Let me just ask this because you seem to agree that the particularized need is no longer needed to analyze because the second order that granted the appointment of an expert was sufficient to cure the whatever error that the first judge had made. But Mr. Huseman argues that the appointment of an expert, granting of an expert, was real effectively. It was not given in a proper time period. It wasn't granted with a sufficient time to utilize an expert properly. So it effectively denied the defendant the services of an expert. So if that is the case, if the defendant, as argued by the government, wasn't entitled to its own expert in the first place, then there may still be an argument that whether or not a defendant has effectively shown a particularized need, and Mr. Huseman very eloquently states what was stated in the record as to the reasons given in the motion. So why is that not sufficient to satisfy, if there in fact was a need to satisfy that requirement?
Yes, Your Honor, you said one thing about the first judge's order being in error, but if you look at the defendant's original motion, and then a motion for reconsideration, he gives a different reason the second time. The first time around, he said he wanted a DNA expert, because DNA is hard and he needs to do this, YSTR testing and challenging the admission. The second time around, he says, he wants it for touch DNA. So this is something that wasn't even before the first judge. So I don't think we could say that the particularized need was shown the first time. So that order was actually correct, but the defendant has said he doesn't even want to consider that. So we have different reasons now on the second, the second time that the defendant is bringing this up and saying, I need an expert now. So,
but he, in the first motion, I mean, it is a fairly scant motion, but he does say an expert witness is necessary to assist the defense in preparing to rebut the government's DNA evidence and to provide defense counsel and assist defense counsel in providing effective cross-examination. That's in the original motion.
yes, Your Honor. And I believe it's in the second one as well, in the motion for reconsideration, but the motion for reconsideration also brings up something else, which is touch DNA. The things that were in the first motion, that judge found it did not meet the definition of a particularized need.
Actually, the initial motion was a little more detailed, where it said that an expert was needed to adequately provide for defense and to challenge the admissibility of the YSDR evidence. And expert witnesses then goes on to say is that the defense in preparing to rebut the government's DNA evidence and to assist, as CJ Torres has pointed out. But there was a specific reference as to why this expert was needed in reference to the YSTR evidence. So isn't that a showing of a particularized need?
If it does show a particularized need, Your Honor, then the defendant would have been entitled to an expert right then and there. And he should have raised this issue at the time instead of waiting almost a year and a half until he had a new judge on the case. It's to us, it looks interesting that he waited until there was a new judge instead of challenging the other judge who was on the case in the first place and seeing if he could get her to change her mind, and instead waited until there was a new judge. And not only waited until there was a new judge, but waited until the new judge had been on the case for several months. So the defendant is the one who prejudiced himself. He's the one who caused the delay here. So if he's
I
complaining.
don't know necessarily of that characterization. I mean, defense counsel strategy as to when to file a motion to reconsider apparently was successful, and if a new judge is appointed who may have a different view in reference to the need of an expert witness, I don't necessarily and the counsel feels that the initial judge it'd be maybe a waste of time to file that motion to reconsider. I don't know necessarily if that's a fault of defense counsel.
I may have misunderstood the argument you were making about the particularized showing in the first motion. I thought your argument was that what they wanted the expert for was to show that the two witnesses were pathological liars, and that they wanted to evaluate the defendant for sexual deviancy. And I thought that was why you argued there was not a particularized showing, why that was important. But that's not really what the motion, as Justice Carvalito read the additional portion, the focus there seemed to be just on the DNA and getting an expert to rebut the DNA evidence, to assist them in cross-examination, and mentions the YSTR DNA. Now you say, well, that's a different analysis than the touch DNA, which was raised in the later motion. But obviously they were talking about the DNA evidence from the get-go, and I didn't see in that this argument you were making about they wanted more of a psychological expert, even though the motion is titled and probably just cut and pasted a motion for a psychologist for defense, but the motion doesn't relate to a psychologist, instead relates to a DNA expert.
Yes, Your Honor, there were like two parts to the motion for the experts. There were two kinds of experts that the defendant wanted in this case, and since it wasn't addressed earlier, I wasn't bringing it up now, but since Your Honor's bringing it up, I can address that. The motion for the forensic psychologist, that was to show that the victim and her mother are pathological liars, and that the defendant has a propensity to commit acts of sexual deviancy. These are things that are the province of the jury. You can't have an expert come in and say, these people are liars. That's something that the jury has to evaluate for themselves after listening to the evidence. And whether the defendant is a sexual deviant, that goes to mens rea, which is kind of the same thing. There's nobody who can come to you and say that what is in his mind. They can't read his mind. Also,
so there were two separate motions originally filed in June, one relating to DNA and one relating to the psychologist.
Yes, that's correct, Your Honor.
And the court denied both.
Yes, that's correct, Your Honor. And if you look at the one about the forensic psychologist, the defendant actually proposed somebody. He had somebody in mind that he wanted to retain. But that witness, he also provided some of that witness's testimony. That witness's testimony depended on another person being truthful, which is this Jonathan Morgan, which is, I think, a friend of the defendant's. No, it was the former boyfriend of the mother. So everything that the forensic psychologist was testifying to assumed the truthfulness of the testimony. He didn't actually know. He was just saying, let's assume for the sake of argument that he is telling the truth. And then this Jonathan Morgan, what he would have testified to, I think the defense is trying to impeach the mother with a prior inconsistent statement. If you look at it, the statement is not inconsistent. It is consistent. She just doesn't understand. I hate to say this, but I don't want to traumatize her. She doesn't realize that what happened to her is a first-degree CSC. The description that she gives of what happened to her, where she says, no, it's not a sexual assault. It actually describes a first-degree sexual assault because she was not able to consent at the time.
Do you think in a DNA scientific evidence case that the defendant is able to mount a sufficient defense through cross-examination of the people's expert witness without the assistance of an expert?
Your Honor, I would say that depends on the attorney and how much experience they have and what they have done to educate themselves on the issue. I know that this
Should the
particular
trial judge make that finding when it makes its decision on the record, whether to deny a defendant's motion for appointment of an expert on the premise that the attorney's experienced and has a DNA background sufficient to permit him to adequately cross-examine?
Your Honor, that might be a good practice because then it would be in the record. In this case, I know that this trial counsel had actually done a DNA evidence-based case before, and I think it may even have been before the same trial judge. So this is somebody who knew how to do this without having his own expert.
Well, that was critical evidence in this case, right?
It is, Your Honor. It was important evidence. And like I said, Dr. Danielson did a very good job. 13 out of 14 counts gets an acquittal. The reason the last one doesn't isn't because he didn't have an expert. It's because of the weight of the evidence. It's because the mother testified, the victim testified, and then Healing Hearts testified, and the DNA experts testified, and they were not able to rule out this epithelial cell that was found inside epithelial cell DNA that was found inside the victim. So even if it had been introduced the way that's described, because the Healing Hearts technician did not use a speculum, the fact is it got introduced because it must have been on her genital area. So this shows that the jury was listening closely, and they realized if it was introduced that way, it's because he must have touched her there. So he must have touched her genital area. Hence, you have a conviction for a second-degree CSC. I touched a little bit on the rape shield law, and I just wanted to point out that
I don't understand how 412 applies to the witness who's not a victim. I know you were making that argument, but when I read, the rule itself and look at that, I think I have a difficult time understanding how that applies to a witness who's not the victim in this case. I know you make the argument that there's, even if 412 doesn't apply, the judge could have, excluded it for other reasons, which that wasn't the basis of the judge's decision to exclude it.
If Your Honor looks at the rape shield statute, it says that a person's sexual conduct is not admissible in any trial if that's an issue in the trial. And so in this case, the defendant was trying to make an issue of the
But that would
mother's.
swallow the rule. And haven't we already ruled in another case that where I think it was, it might have been the Evaristo case. I'll go back and take a look. That you could ask a witness about prior sexual conduct in connection with a credibility issue. I mean,
I was just going to point out
if
that,
it was, if, yeah,
you
go
know, the reason the defendant wanted to ask the mother about this is because if the mother has lied, then the victim has too. Those two things don't necessarily follow. Just because the mother has not told the truth, that doesn't mean the victim did. Here, the jurors are the final arbiters of who's being truthful and who is not. And in this case, they chose to believe both of them. The victim is the one who testified about what actually happened to her, and the mother is the one who testified about facts and circumstances surrounding that event.
Yeah, but what does that have to do with the applicability of the racial law to the non-victim witness? As the language of the rules seems to say that it's the victim that you don't inquire into these type of activities.
Just to show Your Honor that this is not something that affected the outcome of the trial. So this is not some sort of fatal error that made the trial unfair and that entitles the defendant to a new trial. So even if the rape shield rule does not apply to this witness in this case, it doesn't actually make any difference either, because the reason they wanted to introduce that was to propound this theory that because the mother lies, the victim does too. And the trial judge correctly ruled that that's not proper. That's not the way to show that a witness is not credible, that the victim is not credible. I want to turn now to the so-called prosecutorial misconduct. You know, when you look at the prosecutor's cross-examination of Agent Benson, you know, in this case, she had earlier filed a 404B motion in limine to have some prior bad acts admitted, and the court ruled in her favor. And so what she was trying to do here was to get that witness, Agent Benson, to testify to what his investigation showed as to those things that the court would have allowed and would have said was admissible. And I think he was not answering the questions correctly. And that is why she got an objection and that was sustained at every turn. This is not prosecutorial misconduct, however. This is the prosecutor trying to implement a decision and order that was granted in her favor on a motion in limine about prior bad acts. And, you know, these had to do with some inappropriate behaviors by the defendant involving the victim. So they were just trying not to talk about other people and other acts, and it just didn't work. And so I want to point out that, you know, that evidence didn't come in anyway. So it didn't taint the jury. The court does instruct the jurors that statements by attorneys are not evidence. And then there's the weight of the evidence. There's the testimony of the victim and the mother and the DNA evidence. So whatever Agent Benson testified to on the stand, that's not what swayed the jury to convict in this case. I don't think it had any bearing on the outcome. As for the statement that the prosecutor made during her closing argument, that is one statement out of a long speech, and she corrected course immediately. You know, a lot of people say, you know, we talk about matching DNA, and that's just kind of a shorthand because it gets unwieldy to keep saying that the testing could not exclude the defendant as a contributor, so that's just a difficult thing to say. And I think she misspoke, and then she immediately corrected herself. And then you also have the victim's testimony, the mother's testimony, the DNA that is found inside the victim. Also, these are epithelial cells, like I mentioned before, which shows the jury was listening because they convicted the defendant of sexual contact, not sexual penetration. So in this case, there were no due process violations, no constitutional violations. There was no error in barring the evidence about the victim's mother, and there was no prosecutorial misconduct either in closing or when Agent Benson testified. And therefore, we are going to ask this court to deny the defendant's requested relief and to affirm the judgment below. Thank you.
Thank you, Ms. Wallstrip. How much time does Mr. Huseman have left? 3:19.
Thank you, Your Honors. Defendant isn't guilty because he's guilty. He's presumed innocent. He's guilty after a fair trial by the jury of his peers. He didn't get a fair trial here. And the government's response seems to be, but he's guilty anyway. These aren't kangaroo courts we're running. These are impartial, fair trials where the burden, the one person who doesn't have any duties in a criminal case is the defendant. He doesn't have to say anything, doesn't have to do anything. He has to make the government put on a case, and the judge is there to protect that defendant's rights. So the people that have actual duties in this courtroom are the judge and the prosecutor. Prosecutor is supposed to be doing justice. The judge is supposed to be protecting the defendant's rights. We have a problem in this case. Here, there were obviously some constitutional violations, and the government's response seems to be, well, it's the defendant's fault. Again, the defendant is the one person who doesn't have these duties. The government's argument on the—
But on the other hand, if the defendant doesn't do anything,
sure,
isn't that a waiver? of
that
his
can be a
rights?
waiver if the defendant doesn't do anything. The record indicates that he did do things, right? So the record's pretty clear. There's an order here that it grants him a expert witness. So he did do things. Those aren't waivers. And then I would point out to the court, and this is in the briefing, where this isn't the only time something like this happens. There's not a lawyer in this room that would accept a judge denying an appointment of an attorney to a defendant throughout the whole pretrial period, and then at the end of the day, giving the defendant an attorney. That everyone would recognize that's wrong. In this case, and we point this out, if you have a breakdown in communications between a defendant and his attorney, and the defendant makes that motion at the last possible minute, and the judge decides that, well, that has merit, well, then the defendant has rights, and those rights have to be protected. They weren't protected here, and he's entitled to a new trial. The government says that the defense expert did a great job and that they were able to put the prosecution back on his heels. I agree with that. Imagine what the defendant could have done if he had actually had an expert witness for preparation and evaluation of the case, and not just for half of the presentation. That's why he was denied a fair trial, and that's why he needs a new trial. With regards to the rape shield law, I think it's pretty clear that that was an improper use of the rape shield law. The court doesn't have any questions. I'll rest on what I said earlier. I don't want to belabor any points. As far as the prosecutorial misconduct, I understand what the trial counsel the prosecutor was trying to do. It's pretty clear from the record at ER 185. The prosecutor informs the court that she's trying to use prior bad acts to get. She wants to. I don't want to characterize. Let me find what this actually says. Your Honor, I just asked if he was able to confirm behavior. I didn't ask him about any specific acts, what I was able to confirm. And this is helpful to the jury because he's running an investigation And he let me talk about how there is an investigation about other children. So I'm trying to complete the picture, and I'm saying the investigation of this particular child is still ongoing. I'm not trying to bring in hearsay statements. I'm asking whether, did I read the wrong part? I probably am. Yeah, no. I'm just asking him whether he confirmed that there are unusual behavior observed by fellow members. And actually, Your Honor, under hearsay exception 80321, reputation for character among your peers is admissible. In other words, the prosecutor is announcing to the trial judge that she wants to use reputation evidence, which is exactly what she did through leading questions, to say he has a propensity to commit this crime. What's the one thing a prosecutor can't actually do? If the prosecutor wanted to call these parents and wanted to get these prior bad acts in, there was one way to do it, to call the parents and to call the children. The prosecutor didn't do those things. Instead, she summarized statements in an investigation that are hearsay, undisputably, and put her characterization into the mouth of the witness, and then got the witness to agree with her. That's just prosecutorial misconduct. It's facts, not in evidence, and he's entitled to a new trial. And that's what we're asking for today. Any one of these three errors are serious enough to warrant a new trial. We believe all three warrant a new trial. And if there are no other questions, I'll submit.
I don't have any questions. Any questions?
When a prosecutor asks a question and it's responded to, if the witness says, yes, that's true, then what she asks is part of the evidence, isn't it?
Her characterization becomes part of the evidence. That's correct. But the problem in this case is, yeah, she's saying these facts aren't in evidence. She's putting them in front of the jury. And then he says, yes, that is true. Okay, so that becomes evidence, but it's improper evidence, right? It's none of those facts are actually there's no place to find any of those facts in this record except for the prosecutor mouthing them in an improper leading question that turns out to be hearsay anyway.
So the instruction about the attorney doesn't present evidence isn't true when it's part of the question, isn't it?
It doesn't cure this problem, because when the witness adopts what the prosecutor has said, then it becomes the witness's statement. So there's no way to cure the blanket cure is completely insufficient in this situation. That's why we've said that. If there are no other questions, I will submit.
All right.
Thank you, Your Honors.
Thank you, Mr. Huseman. Thank you, Ms. Wallace-Chuck. The court will take the matter under advisement and wish you a written opinion, and will now stand adjourned.
All right.